This is our presentation by John Branning and Tess Baer for Legal Ethics Presentation Number 1.
On December 5th, 2018, Michael John McNulty was disbarred from the practice of law. In his case, he violated many rules of the ABA Model Rules of Conduct, which include Rules 1.3, 1.4, 1.5, 1.16, 4.1, 8.1, and 8.4. Now, to provide some background on the case, here is what led to the complaint brought on by Mr. McNulty's client, Mr. Thomas. Mr. Thomas alleged that Mr. McNulty failed to effectively communicate with him. Mr. McNulty failed to attend meetings, failed to respond to emails from Mr. Thomas, and after all of this lack of communication, Mr. McNulty simply abandoned Mr. Thomas, his client. After Mr. Thomas was abandoned, he had to immediately search for new counsel.
Mr. McNulty was definitely punished for his misbehavior. Various punishments were incurred. One was that he had to make restitution to the clients, which totaled $1,125, which probably paid for the next lawyer. Mr. McNulty also had to make restitution to the Tennessee Lawyers Fund for Client Protection, and he had to prove that he had made that restitution. He had to meet all of his CLE requirements before he could be reinstated, which, by the way, at the time of this publication, he had not been reinstated. And he also must pay court costs, which amounted to $583.18.
Now, what is the rationale behind the court's decision? In the end, they said that among all of the rules that were violated by Mr. McNulty, the one that we will discuss here is Rule 1.16, which concerns the termination of representation. Rule 1.16 states that a lawyer, upon deciding to terminate representation, shall give reasonable notice to the client that this will happen, and a lawyer shall give his or her client enough time to find and employ new counsel. And so how do we tie in this rule to the facts of the case? So the first part we'll focus on is giving a client reasonable notice. So did Mr. McNulty, when terminating representation, give his client, Mr. Thomas, a warning or notice that he was going to terminate representation? The answer is no. As stated in the background of the case in the summary, Mr. McNulty abandoned Mr. Thomas, his client. He gave him no warning that he was going to terminate representation. He just simply stopped talking to him, didn't meet with him, didn't answer his emails, just straight up abandoned him. So that's one part of 1.16 that Mr. McNulty violated. The second part that I mentioned is giving his client enough time to employ new counsel. And so if we carry on from where we left off, did Mr. McNulty give his client, Mr. Thomas, enough time to find and employ new counsel? Once again, the answer is no. After Mr. McNulty abandoned and seized all communication with his client, Mr. Thomas, his client was forced to immediately find new counsel. There was no grace period. There was no, hey, I'll work with you until you find new counsel. It was Mr. McNulty abandoning Mr. Thomas, and Mr. Thomas, the client, having to find new counsel right off the bat. There was no warning. There was no notice that he was going to terminate representation. And so the fact that Mr. McNulty once he failed to give notice to Mr. Thomas' client, and secondly, he failed to give Mr. Thomas enough time to find new counsel. For these reasons, the court decided that Mr. McNulty violated these two sections of Rule 1.16, and they found that he acted unethically.
Mr. McNulty had been disbarred previously, so having these items that he held on his misconduct just fortified the aggravated facts. They emphasized the aggravated facts. He falsified emails. He lied about a medical professional, and he also sent an email as if it came from someone in the office that didn't work there anymore. After all of that, he failed to attend the disciplinary hearings. So those were all aggravated facts that caused the hearing panel to disbar Mr. McNulty.
The hearing panel did not find any mitigating factors. Now, here's the difference between a mitigating factor and an aggravating factor. An aggravating factor is something that, once presented to the hearing panel, makes the crime or the ethical violation much more worse. As we've mentioned, Mr. McNulty, he falsified emails, he lied. The fact that he'd previously been disbarred in the past, the fact that he failed to appear to his own hearing, those made his ethical violations worse and therefore are aggravating factors. On the other hand, mitigating factors are ones that, once presented, can make the ethical violation understandable. While they don't excuse the violation, they make the judge or the court or the board more lenient on the case of Mr. McNulty. In this case, there are none of these mitigating factors, and the panel can continue with their decision.
The best way that Mr. McNulty could avoid this type of situation is to do the right thing. He could always provide professional service and, of course, to not lie. Lying will always catch up with you. Don't abandon your clients. Stay with them until they find other counsel, if need be. And never, never ignore the court. Always go to your hearings. And this is how we found, both John and I found Mr. McNulty to be disbarred.